For the video comments.
Good afternoon, everyone. We are here again today. Let me give you guys some time so you can, if you're on social media, Facebook or wherever you are on, we want to give you enough time to post the information on your respective links so people can participate in this healthy conversation. Today marks the this month marks Mental Health Awareness Month, and so part of our web series, we wanted to make sure that we provide our constituents, our residents, enough information to make informed decisions about their family, about their lives, about things that are critical with them. And we also know we have some experts who are doing this work in their respective fields. And so we are lucky, we are fortunate enough to have people who are not only experts of doing a tremendous amount of work, but also they're able to answer your questions in real time, to provide information to you. So please do not hesitate. We'll try to answer as many questions as we possibly can. And so let's get started. First and foremost, thank you for participating. And so today we are glad to have a number of good people who are participating in this conversation. First, let me introduce my co-host, Devere McDougall. He's a deputy surrogate here in the county of Essex. He is a very smart person in this space. He's an attorney as well as CPA, and he provides a wealth of information, wealth of knowledge of what's happening in this area. The next person is Deana Critchley. She's from the Counsel here in Essex County. She's on loan to us, but most importantly, she represents a number of families, a number of children with the respective hospitals. So I'm gonna let her introduce herself. So.
Oh, hi. How are you? I work for the County Counsel's office, and I actually represent you, the people of the County of Essex, in mental health commitment hearings. So I'm at the beginning of the process, the legal process, as far as the commitment process. And I am here to protect the members of the community of Essex by making sure that those individuals who are proven to be dangerous to themselves, others, or property as a result of their mental illness will be committed to hospitals until they're no longer dangerous. So I actually go to different hospitals throughout the county, and we do hearings there. We have a judge, and the hospital is the witness. The doctor is there. The patient is there. The patient has an attorney assigned to them through the public defender's office, and we proceed with the hearing. And it's a very high standard to prove that somebody is a danger to themselves, because essentially you're taking away their liberty by keeping them in a hospital against their will. Some patients do consent to stay, and they realize they want the treatment. Others don't, or they're unable to based upon their condition. So at that point, we proceed with an involuntary commitment hearing. And that's the beginning of the process.
Voluntary. Thank you very much. Next one to bring up, Crystal West Edwards. Every time we call, she finds herself and makes herself available to us. She's an expert in this space. So go ahead and introduce yourself, Crystal.
Good afternoon, everyone. Crystal West Edwards. I'm a principal at Porzio, Bromberg, and Newman. My practice area is elder and special needs law. And so for purposes of this discussion today, we're going to touch base on some rules related to guardianships and people being deemed incapacitated or incapable of managing their legal, medical, or financial affairs, whether that be an older loved one or whether that be an adult with a disability that needs assistance as they attain the age of 18.
Thank you, Crystal. Joining us also, we have Kecia Burnett. Kecia Burnett is the director of Division of Family Assistance and Benefits. So please introduce yourself.
Good afternoon, everybody. I am Kecia P. Burnett, the acting division head for the Division of Family Assistance and Benefits. We are responsible for social service programs, SNAP, which is formerly known as food stamps, cash assistance for families and for individuals. We provide emergency assistance, with assisting with housing and shelter. We have, of course, NJ Family Care and Adult Medicaid. And I also happen to be the Moore Keeper for Essex County.
The Moore Keeper, okay. We'll get into that, during another conversation. I want to also bring on board our judge, from Passaic County, our sister county, who is always made herself available. She is not only an expert, in that space, but also she's providing good work for her residents in Passaic County. Bernice Toledo, our judge. So introduce yourself, please. Ms.
Good
Toledo, can you hear us?
afternoon. This is
Got it.
Bernice Toledo from the Passaic County Surrogate Court, and I thank you, Judge Kenny. I thank you, Judge Kenny. I thank you, Deputy McDougall, and everybody here on the panel for putting out this very critical information. Thank you.
Thank you. I just want to read some facts real quick, and then we'll get into this conversation. Earlier on social media, I posted something about Mental Health Awareness Month. Some facts that I wanted to share with you. In the U.S., almost half of adults will experience mental illness in their lifetime. 5% of adults experience a mental illness in 1 year. 3, half of mental disorders begin by the age of 14, and 3/4 by the age of 24. Only 41% of people who had mental disorder in the past year receive professional help. And number 5, mental health treatment increased from $171 billion in 2009 to $280 billion in 2020. And so I wanted to share that information because mental health is a reality, for a number of individuals in this country. It will touch the lives of people that we know. It will touch our lives, individually, someone that we love, maybe a family, maybe someone that we're very close to. So this is a very important conversation. And so I wanted to make sure that we have at least some facts to guide this conversation. So since we have Kecia online, and I know we had a conversation about Medicaid and Medicare, and that impacts this space. What is the difference between Medicaid and Medicare, Kecia, and how does that impact this conversation that we're having?
Medicare is the medical insurance that is issued by the Social Security Administration. Medicaid is for individuals who need full medical and or supplemental insurance, and it's issued by the County Welfare Agency as well as the Social Security Administration. Medicaid, there are different forms of Medicaid. Specifically, Medicaid, the Medicaid that is issued through Social Security Administration for the elderly population is called age blind and disabled. Individuals with mental health issues would be considered for the age blind and disabled program. And they would come and they would apply and they would be offered the medical insurance so they could get the care that they needed.
Okay. So if you have access to both, you can use this funding source to get services and treatment. Is that correct?
Yes.
Okay. And what are some of the requirements?
Well, it's a very intense application. It's not as simple, but if you are disabled and it's medically identified, we can do what they call presumptive eligibility, so there's no waiting period. For instance, if somebody's in a crisis, you can do presumptive eligibility.
And what is presumptive eligibility? Because I'm not in that space.
Okay. So what happens is we need to know your source of income, all of your household expenses, any outstanding debts that you might, financial debts that you make, all of your income. Basically, income is the major thing. Okay.
Okay. Thank you. And so does a child receiving SSI automatically receive Medicare?
A child on SSI will not receive Medicare. They will receive Social Security administered Medicaid.
Okay.
So, if you don't mind,
Medicare is 65 and over.
all right. So if you don't mind, if Crystal can talk about Social Security insurance, because that is an area of your expertise. If you can talk about that and Social Security disabilities for benefits for people with disabilities as well.
Sure. So the first thing I want to mention, which is just to piggyback off what Ms. Kecia just said, the Medicaid program, unfortunately, has not been designed to be user-friendly. So what that means for lay people is that we talk about the Medicaid program, but there are multiple programs that one could qualify for in order to tap into those services. And so your circumstances are going to really differ and point you into a specific door to walk into to qualify for Medicaid. On the Social Security side, if someone has been deemed medically eligible to receive supplemental security income benefits, and I'll talk about what that means in a minute, but SSI, for those that are familiar with SSI, the state and federal government, New Jersey and the feds, have agreed that anyone who receives SSI that is a New Jersey resident will automatically be enrolled in our New Jersey Medicaid program. So we call that categorically linked. If you Google that, our New Jersey Medicaid program is categorically linked to SSI. An SSI recipient gets Medicaid automatically, but they do not qualify, initially anyway, for Medicare. Medicare is a program that is designed for seniors, so for individuals who have reached the age of 65 and older, or for people who have been deemed disabled by the Social Security Administration and have waited a 24-month period. So what does that mean practically? I have a child, let's say I have a 20-year-old, and I need to apply for SSI for my 20-year-old. Well, in that circumstance, we would look at, do they first meet the medical criteria for the program? So we would have to show that they are incapable of engaging in what's called substantial gainful activity. So basically that they're unable to work and earn a certain dollar threshold. And if we can establish that, then the next thing we look at are assets, money in the bank. How much money does the person have, or things that they could use to convert to money that could pay for their services? And the threshold for that is $2,000. So it's a very low limit. There are exceptions to the rule. There are resources that we don't count, but generally we're talking about $2,000. For income, the SSI program is effectively a federal welfare program. So that means that if someone is working and earns, let's say, $200 a month, working at ShopRite or delivering newspapers, then some of the earned income that they receive would offset the amount of SSI money that they would get. But the general rule, keeping it very high level, is that SSI could provide someone this year in New Jersey just over $800 a month of monthly income. That same person, though, using that example of a 20-year-old child, if that child's parent either passes away, becomes disabled him or herself, or retires, then the same child who, or I should say adult child, who qualified for SSI in and of themselves for medical and financial purposes could also be deemed a disabled adult child, which would mean that they could tap into the Social Security resources of their parent. If they were to do that and wait a 24-month period, they could then receive Medicare benefits through the Social Security Administration. And in that circumstance, potentially would be what we call a dual eligible, someone who's getting Medicare and Medicaid. This program that I'm talking about right now is one of many Medicaid programs that someone could qualify for. So again, circumstances are going to be very different, but that's the interplay between the feds and the state with respect to Medicaid and Social Security.
All right, thank you. So what I'd like to do is also now let's talk about protecting those benefits. So you gave an example of a 20-year-old and parents pass away. So let's say the parents pass away and they leave assets to that child. Would that impact their benefits? And let's say substantial benefits. So, parents had a house and had a decent amount of money, and it's a respectable amount of money in the bank, but they had a house. And as we know, houses in themselves, it for many people is most of their wealth. So let's say parents passed away and left that child a house. Would that impact their benefits?
It absolutely would. And so the theme for those who've been attending the various webinars that have been going on over the past few weeks, we talk about planning and how important planning is. There are specific rules that would allow someone who has money and is under a certain age to still qualify for SSI or Medicaid benefits through the use of special needs trusts. So let me just mention what a special needs trust is, and then I'll talk about the planning piece of why it's so important. So a special needs trust is a federal concept that we also have on the state level that allows someone living with a disability to be able to fund a trust for his or her benefit, or that trust can be established on their behalf by a parent, grandparent, guardian, or the court to hold money that essentially can be used to supplement but not replace what government benefits would provide. In exchange for the agreement for the state and federal government to pretend as if you don't have money by putting it in a trust, you are also agreeing that when you pass away, the Medicaid agency is entitled to be reimbursed from that trust the amount of money that they've paid out for you during your lifetime. That's what we call a first-party special needs trust. So in the example provided, 20-year-old is getting SSI benefits and is also receiving Medicaid benefits, and their loved one just passed away, and they now are the owner of a house and a $100,000 life insurance policy. In order to continue that person's eligibility for Medicaid and for SSI, it would be imperative, to the extent that the person is under the age of 65, which in our example, they're 20, that money and that home can be transferred to a special needs trust for his or her benefit that would allow them to continue qualifying for those government benefits. On the other hand, excuse me, if the parent had done some planning through estate planning with a special needs attorney, they would have been able to establish a very similar trust, what we call a third-party special needs trust, the trust that is still intended to supplement but not replace government benefits. But by the parents having the foresight to do it in their estate planning documents prior to the time of their passing, it would avoid the requirement for the Medicaid payback that I mentioned. So planning is key. And why is that important? I mean, I know I've got government folks on the webinar, but nobody wants to voluntarily give the government money. So to the extent that any money that's not used for that 20-year-old adult in our example, it could then, with proper planning, be utilized for other family members at that person's passing, as opposed to reimbursing the state of New Jersey.
So let me ask you, you talk about special needs trust. So I'm going to throw out another term out there, and I'm just going to use the acronym. How is ABLE accounts different than special needs trust? And are they better? Could they be possibly better for, let's say, somebody who doesn't have a significant amount of money to get an attorney to put a trust together? Excellent
question. So I'm going to answer it, and then I have a little spin I'm going to put on it. So what a lot of people don't know is that ABLE, Achieving Better Life Experiences Act, was a way for people to establish accounts that are very similar in nature to 529 plans that are used for education to be used for qualified disability expenses. So what that means is, using that example of that 20-year-old who received some money and they need to qualify for Medicaid, one could establish an ABLE account and fund it. However, the way that the folks who initially introduced the legislation envisioned this to work is very different than what the finished product was. So for ABLE, there is a Medicaid payback to ABLE. So an ABLE account is not, in my humble opinion, a good planning tool for mom and dad for purposes of ensuring that when child ultimately is gone, that money is continued for other generations. An ABLE account does have a Medicaid payback, number one. Number two, you can't just fund it with the house. In our earlier example, an ABLE account can only be funded each year with no more than what the annual gift tax exclusion is per donee. Gift tax exclusion is for that year, which this year is $15,000. So if someone is only getting $10,000 of a life insurance policy, ABLE may be a great way to go. If they're getting a house and $100,000, ABLE is not going to solve their problem. The money that accumulates in an ABLE account is exempt for Medicaid eligibility purposes. ABLE is also great to avoid some of the administrative red tape that the New Jersey Division of New Jersey Division of Medical Assistance and Health Services has us jump through annually with regards to reporting requirements and notification of expenses over a certain amount. But it is important to note that once an ABLE account exceeds $100,000, then the beneficiary will lose SSI, that monthly, roughly $800 income stream, but they could stay on Medicaid. An alternative to an ABLE account, which people don't often talk about in these types of settings, would be a pooled special needs trust. A pooled special needs trust in concept is when multiple beneficiaries come together and have their special needs trusts administered under an umbrella. And that umbrella in New Jersey is administered through Plan NJ, Plan Lifetime Assistance Network of New Jersey. And that would be a good way for someone to still have a corporate trustee, have a special needs trust, but not have to worry about that Medicaid payback that would exist if they funded the third party pool trust, in an ABLE account circumstance.
Thank you. So in this vein, I want to kind of go to Surrogate Toledo, because Ms. Edwards talked about the fact that we need the plan, especially when we talk about special needs trust. Have you ever experienced petitions being filed with the court when people haven't planned?
Okay, so first, Ms. Edwards mentioned you have to plan, but you also have to communicate. It's not just limited to planning, it's limited to communicating with your family members, because this is what could happen to your child. Your child who needs Medicaid services or government services can become excluded from their services, or later disqualified from existing services, get kicked out of, expelled from a residential program, if a well-meaning grandmother names the developmentally disabled child or psychiatric child as a beneficiary on their life insurance policy. If grandma leaves some money, a few $1,000s, just because she wants to make sure that this particular grandchild, a child that may not work for the rest of their lives, that they're taken care of. But what'll happen is they'll burn quickly through that money, they'll become disqualified from the program, and many state-run residential programs, won't even accept you if you're self-pay. Even if you're a millionaire, they won't accept you. They want to know that that money is coming and that you qualify through government benefits. The waiting period for some residential programs is years long. So by failing to communicate with your family, even though you're doing all the right things, let's say you're doing the ABLE account or the special needs trust, if grandma, auntie, somebody leaves money to your child one way or another, it can be a problem. Now, another thing that I also wanted to add was with respect to the ABLE account. It's only eligible for people, candidates, beneficiaries who have had a condition existing prior to, and Ms. Edwards, correct me, is it prior to age 25?
26.
So 26. So if, let's say you were normal functioning your entire life, and then somewhere along the line you get Alzheimer's, you are not a candidate for an ABLE account, because Alzheimer's is generally a degenerative disease of the brain which affects the older population, correct? If you get into an accident where you have traumatic brain injury at age 30, you are not eligible for an ABLE account. That would be a special needs trust part. So that was on the existing issues that we've already discussed. And the question, McDougall, was about planning and guardianships, correct?
That guardianships is one of them, yes. Adult guardianship.
Okay.
You can mention that.
So with respect to adult guardianships, once your child reaches the age of capacity, that's age 18, once your child turns 18, your child is, until adjudicated otherwise, has capacity, has total and perfect capacity. So in the eyes of the law. So it's becoming more and more important for a variety of reasons for a guardianship filed, so that you can be in charge of if your child is incapable of doing so that you can be in charge of your child's affairs. Nowadays, with things like HIPAA, which is being strictly enforced, HIPAA is the Healthcare Privacy and Portability Act. It's basically your medical privacy. With HIPAA, you can't speak to the insurance companies. Maybe a doctor who reads it strictly, and he would be right, won't discuss your child's condition, your 19-year-old child's condition, when you know that they don't have the capacity to make decisions for themselves. That's when a guardianship comes in. So for a guardianship, you file a complaint. We call it a complaint. You're not actually, complaining, but it's an application with the court. You file a complaint and an order to show cause, so that your child can be adjudicated. It means it says, yes, I agree. This person, who is now an adult, does not have the capacity to function for themselves. And it can be a wide variety of reliefs that you get. Sometimes it's only for the person, and if your child has some sort of assets, it'll be for the person and property. So that's a guardianship in a nutshell, and it helps you step into the shoes of your child so that you can care for them without objections or interference by schools, by government agencies, Social Security, or even by objections by the child himself or herself, because sometimes children are high functioning. Sure, they're high functioning, but they don't have the capacity to function at full level. So maybe and this is the more dangerous situation, where you have somebody who's high functioning and they appear to really understand what's going on, but they really have a capacity of maybe a 10-year-old child. That's not sufficient for them to really appreciate the seriousness of needing medical care, of turning down medical care, of enrollment in school, things like that. And that's why guardianship is important.
So let me ask you this. So many people are Social Security representatives. Does that give them the same rights as being a guardian?
No, not at all. The Social Security representative is for the purpose of transacting with Social Security. A guardian is a blanket right to step into the shoes of those who cannot. So I'm from the surrogate's court, and we know that surrogate is one who acts on behalf of another who cannot. That's what you're doing in the surrogate's court when you file that guardianship application, when you file that complaint. You're stepping into the shoes of your child who cannot, for a multitude of things. As I said, it could be of the person only, of the person and the property. If you're a Social Security representative, you don't have the right to deal with all these other agencies, with school agencies, residential programs, or anything like that. Not at all.
Thank you. So you said something earlier that I want to bring in, Deana. You said earlier that sometimes people can have, disabilities later on in life, let's say, and let's use example 426. So let's say you end up being diagnosed with schizophrenia. A lot of our families don't know what to do to get that person help, because obviously that family member at that point in time is going through something. So Deana, could you explain how families can get that individual the possible help that they may need, because they're not willing to seek the help that they may need themselves?
Sure. When a child is under the age of 18, it's much easier to obviously get the child the help they need, take them to the hospital because they are a minor. But once they turn 18, and often in schizophrenia, we see these breaks happening in the early 20s. So that's often the case that I see, where parents hear from their child from college, or something happens while they're away at college and they're having a break. And the parent does not know what to do or how to get their child help. There are screening centers in every county of the state of New Jersey that you can either bring your child there, or you can call, and they have mobile screeners that will come out and screen the individual for mental illness to see if they're a danger to themselves, others, or property. And if they find that they are a danger to themselves, others, or property, they will involuntarily commit them for a temporary period. And then we come in and do a full, within 20 days, they have to have a full hearing with the judge and everything like that. So there is a way to get help, even when your child says, no, I don't want it, or they don't understand that they need it. You can call a screening center. And if you don't know where your screening center is, well, you can look online. Call your local police. They all are involved with screening. It's a normal part of their job to help people in this regard. They're there for you. And the people at the hospital are there to help you and walk you through. They have wonderful social workers and doctors at these hospitals who really can help to navigate you through the process, as well as the attorney that will be assigned to every patient is assigned a public defender to represent them. So
I have a question, because so one of the things that it came to mind is that, prior to this conversation, I was just doing some research, and Passaic County and Essex County, we have very, similar communities. We have high affluent, and then we have communities that are struggling. And so, and so the thought process was that people needing services, how do they start? Where do they go? And the other part of it is that the income aspect of it. I know we talked about some of the programs that are eligible, but there's also the fear that if I decide to seek help for a loved one, I may not be able to afford it. I may not be able to and it's also the cultural aspect of it. A lot of us don't think that we need the services because, it's just an admission, that there's something.
Stigma. Yeah, the stigma.
Yeah,
Right.
that stigma. So, if someone can walk me through the process, where do you go? Is it forced? Is it voluntary? And then then the service aspect of it, we have a lot of content in terms of services. Like, just give me some more information on what can happen. And also, if anyone else is watching, you have any questions, please ask your questions in the box, below. We will answer those questions as this conversation develops.
And could you include immigration status into that with the question that the surrogate also asked? Does that?
I'll just jump into the beginning of the answer for this question, and I deal with the involuntary commitments in
Okay.
Essex. There are people who want help, are asking for help, and they will not necessarily go through the process of going to a county or a state hospital. They can voluntarily sign themselves into a state hospital, and we have voluntary units at most hospitals for people who are voluntarily saying, yes, I need the help and I want it. There's also private facilities. There's just so many options for people in this situation. And as far as income, the private facilities are going to be different than the state or county. The county and the state facilities are paid for by the taxpayers of New Jersey. So it's the people, I don't believe, are leaving with a bill. And that's where Medicaid and Medicare, all those things come in. The social workers are there also to help those patients. If they do not have the benefits, they help them apply for those benefits. And they're excellent. They know the ins and outs. They set up Social Security appointments and walk them through that process. They set up trying to get Medicaid. So they are there to help them do that in the situation where somebody has no benefits. And often, De'Vera, those are immigrants that don't have the benefits, and they come in with nothing. And it's very hard to get a placement when you have no benefits, because the placements, the residential facilities, the outpatient, all those different facilities are paid usually through the benefits. So that's a problem for somebody who has no status, no immigration status, and no benefits. But again, I've seen social workers apply for citizenship for a patient and get it. Takes a long time, and the patient's in the hospital during that entire time, but they are able to help navigate those issues. So.
In Passaic County, we run into a lot of obstacles, and the obstacles exist whether or not you're private or you're public. There's a shortage of psychiatrists. When you call a psychiatrist, waiting lists take a long time. What I have seen is that as of, I guess, 1 or 2 years ago, there was a special grant in New Jersey whose name escapes me, but it's a collaboration between pediatricians, and I know one of the participating hospitals is Morristown Memorial, so that when you take your child for their well baby visit, remember the well baby visits go until they're 18, they ask the questions about psychiatric issues. So that's a way that you can get yourself in because of this recent grant, because now we're actually saying, okay, this is a condition, right? So it's just like when you break your leg, just because you can't see it doesn't mean that the condition exists. And mental health is more than just, we talked about schizophrenia, and that's really significant. That's obvious. There's some psychosis involved, but there's subtler forms of mental health that also need help because it will compound. One of those things is anxiety. People think anxiety is just, anxiety, you're nervous, you're stressed. Anxiety is the flip side of depression. And depression can be crippling. Bipolarity, ADHD. ADHD is a mental health issue which needs the help of the prescriptions of a psychiatrist. So one way is that way through the pediatric system. Call it Medicaid psychiatrists are hard to come by, at least in Passaic County they are, and private ones as well. So our experience is you have to be persistent. One problem that I found, remember, I see a lot of these cases, and I am by no means a mental health professional, but through my experience, I see it all the time. And one thing that's a problem is stabilization of the patient. So you have a headache, you take a acetaminophen, a Tylenol, and in 20 minutes your headache is gone, or at least controlled, right? That's not how psychiatric medications work. So if you see the signs in your spouse, in your child, and in a family member, you have to act quickly and persistently, because if you take medicines today, let's say you're taking lithium for bipolarity, by the time it actually kicks in and it's stabilized in your bloodstream, it might be a month, only to find out that your level was off, that they gave you too little, or that medicine wasn't right for you. So now they've switched you to something else. And that takes a month for it to stabilize in your bloodstream at a therapeutic level. So there's lots of obstacles to psychiatric care. There's lots of obstacles to mental health, and stigma, yes, is one of those things. But you have to be persistent, and you have to keep on with respect to getting services. Oh, one more thing. If you have a teen or a child that's having a crisis, there's the mobile response unit. So you call, and it's a division of DCP&P, and they send out a mobile response unit to stabilize your child. And that can either result in some sort of short-term plan, or even taking the child at that moment to a psychiatric hospital. In these areas, we have one at North Beth Israel, in Boonton, it's St. Clair's. There's a few psychiatric hospitals in the area for when your child is in absolute crisis and there's no immediate stabilization to be had.
And Trinitas has a minor unit as well.
I have a question that came in. So a parent said, my son was diagnosed with schizophrenia. He is now compliant with his medication. However, he is still struggling with managing his business. We have applied for Social Security for him. Right now, he's high functioning, but that can change from week to week, and has dependent it has depending on medication compliance. It's a day-to-day struggle. So my struggle is, do I or should I seek guardianship on his behalf?
Well, see, the problem with that is it seems like he's high functioning, and he could object. So to file a guardianship, and let's start with that, right? So you should consult an attorney. An attorney is the best way and the best method to get a guardianship filed and to get an adjudication, a judgment of incapacity, right? But there are pro se forms for the self-represented litigant on njcourts.com. You go to forms, and there's a zillion forms there. What I recommend, call your surrogates court in your respective county and ask them to send you the precise link or to give you a packet so that you know what you're looking for, because it's kind of hard to navigate the website. So that being said, you can fill out pro se forms. That's easier for somebody who's had a long-standing condition. They've had Down syndrome since they were born, so that's easy, right? But you have somebody like you just described in the question, somebody who is managing a business, who's high functioning, and is at this moment medication compliant. When you file for a guardianship, that guardianship has to include a diagnosis, schizophrenia in this case, and a prognosis. He won't get better. But in this case, what you're telling me is he's better for now. And if when you apply for this guardianship, he's objecting, then chances are that any court will be very reluctant to grant that guardianship. If he can prove that he can function, that he can handle his affairs, then chances are that you file for the guardianship and you will not be granted. The courts do not take it lightly. If it's somebody who has had capacity and been independent through their lives, the court will not take it lightly to strip that person of the ability to care for themselves.
And if you do it yourself, as a pro se litigant, if you do it yourself, I want you to understand that the court will appoint him an attorney as well to fight for him, not to do what's in his best interest, but to act as their zealot advocate and to fight tooth and nails for him. As long as what he doesn't request is what we call patently absurd, the lawyer will fight for him. So you have to be mindful that if you're going to do it on your own, you're going to be going against a lawyer.
So let me pull Crystal in for this follow-up question. No, I'm going to pull you in, Crystal, for this follow-up question, because she also stated he has been committed 4 times in the last 2 years. Just to give you more information to that scenario.
Okay, so yeah, that's what I was initially going to say was practically we would attempt to see if he would be willing to sign a psychiatric advance directive. So basically a healthcare directive where he's appointing a representative to act on his behalf medically. Additionally, if he has capacity, since her initial comment was about helping him manage his business, and I don't know if that was an actual like LLC business or just his daily affairs. But
Daily affairs.
Would, yeah, sorry, I lawyered, right? But perhaps the signing of a power of attorney would do it. So a power of attorney and a medical directive are what people who have the mental capacity to make decisions for themselves but need assistance can sign in order to kind of tag someone else in to assist them. Practically, though, in this space, it does get a little bit difficult because if he's at one of those moments where, maybe the medication is not appropriate, the things that Surrogate Toledo was just mentioning, you certainly can revoke a power of attorney and a medical directive, and then you end up in this cycle of when's a good time to file. Is a good time to file while he's committed? Is a good time to, and then it can get very, very complicated. But initially, to the extent that he were willing, while he's in those lucid times, to voluntarily sign a power of attorney and a medical directive, we would try that first.
Thank you. Kecia, I know we have you here, and so benefits, and one of the question was, one of the follow-up questions in my mind was that, are we leaving benefits on the table, regarding services that are unused, untapped into? Are there benefits, on multiple levels that are that could be accessed, but we're just not accessing them because of the stigma, because we're just not applying or using the services that are offered to us. So maybe you can give some guidance to that.
Okay, I need a little clarification when you're talking. Are you talking medical benefits? Are you talking cash benefits? Are you talking about everything that we offer here at EPAB?
Whenever you hear benefits, is whatever you think, whatever you decide.
Okay, in my mind, it's everything.
Everything. Because
if a person is receiving Medicaid, more times than likely they are SNAP eligible. What happens is they're issued an EBT card. If they don't use their benefits within 5 months, the system automatically closes their case and they can't access them. What we try to do is in our office, we have a group of people who monitor the SNAP benefits. So if the benefits have been on there and we say that they've been unused, someone in investigations will reach out to that person to see if maybe they lost their card. In some situations, they have been hospitalized, which then presents another problem because though the benefits were issued, if you're hospitalized or institutionalized, you're no longer eligible for SNAP benefits. So now I have to automatically close your case or have your case closed, but then you're not going to be able to use the benefits that were issued. We're going to have to take them back if you were in fact hospitalized. So we try our best to keep up with that to prevent that from happening, especially when it comes to senior citizen population, because they may not be institutionalized, but they may have benefits that are on the card, but they've been home and they couldn't get out and they don't know what to do. So then we have outreach, well, before COVID, we had outreach to go and assist them and see if maybe how we could get them to the grocery store or get someone or advocate for them to get someone to do that for them. We try not to allow people to lose their benefits, but in situations where you disappear, you didn't recertify, you didn't do a redetermination, you're going to lose them and then you're going to have to start the process all over again.
Thank you. Now I had a follow-up question to Social Security, and I'm going to relate it to something we do here as adoptions. So I pose this to Ms. West Edwards. So if grandma, aunt, uncle was raising a family member, and is it possible for them to utilize adoption as a planning mechanism to ensure that their Social Security would go to that individual?
So it's a trick question. Okay. And the reason it's a trick question is because if we're talking about someone who's tapping into Social Security benefits as a minor under the SSI program, they may qualify, child may qualify for SSI benefits with the deeming. Deeming is the rule where we look at what a parent has and we apply what the parent has to the child. That's deeming. Deeming from the parents to the child may still have the child eligible for benefits, but if the child were adopted and the grandparents were in a different financial circumstance, now their new legal parents, the deeming there could potentially disqualify them. So that's something to just be careful about on the SSI side. On the Social Security benefits side of being considered a disabled adult child, those other benefits that we were talking about earlier, adopted children do qualify for that, but that would be children adopted as a minor. So adult adoptions are not ideal in that circumstance. That's something we should really look at on a case-by-case basis. There are limited circumstances where a grandparent, where Social Security benefits from a grandparent could be utilized for a grandchild, but that is a very sliver of an exception to a rule. So the general rule is not without an adoption, but you'd need an adoption as a minor.
Thank you. So I see we have approximately 10 minutes left. So what we would like to do is open up the floor to all of you that are here to, if there's anything that wasn't asked that you think we need to let the viewers know about, please, let us know if there was something missing that you think is important that we need to still provide to our viewers.
I do want to
And also, let me add one more thing. Also to my judge in Passaic County, also, if you can identify some resources that your constituents could tap into, I'll type it into the box, and also I'll make sure that folks can find it so they can receive the information.
I did want to mention something that was in response to Surrogate Kenny's question about benefits that people don't necessarily tap into. In the population of people who have loved ones with intellectual and developmental disabilities, in the past, and I mean decades ago, parents would simply disinherit their child that had an intellectual or developmental disability to avoid them being disqualified for government benefits. That is not something that really needs to be done any longer, because there are ways to protect those benefits with special needs trusts. At the same time, during those time periods, people were not as willing to go through the process of classifying their loved one as having an intellectual or developmental disability. And so what that looks like practically today is that in order to tap into services available through the New Jersey Division of Developmental Disabilities, that would be a residential housing situation, vocational rehab. There are tons of programs available through the New Jersey DDD. In order to tap into those services, we have to show that the disability existed prior to age 22. So if I'm representing now someone who has special needs and they're 55, I've got to recreate medical records from when they were in their teens and early 20s to tap into those benefits. So even if you have someone who you think is going to be able to manage their life and manage their affairs, it's still really important to look at getting an assessment to see if they do qualify for those benefits, so that if they're needed decades from now when you're no longer here, they can tap into them.
Thank you. Judge?
So, Judge Kenny, maybe you can put up a link in the box with regard to the New Jersey Resource Handbook. There's a handbook which I found very useful. You can get a physical copy of it, and there's also an online copy of it, of the different resources, benefits, and programs that they have available in New Jersey. And I'll give you an example of one of them. We don't have this grant in Passaic County, but I know that they have it in Bergen County. So it's a grant which will get you I think it's called a PPE or PPA, which basically is a personal assistant. So let's say you suffer from extreme anxiety. You're in your 20s, you need to go to college. This person will, your personal assistant will ride the bus with you, will sit in the back of classes with you. Maybe you need help toileting, will help you with things like that. You can always go to your counties, like call the county freeholders. Some counties do have a representative whose sole job is to provide services for people who have disabilities. So that's one thing. So go to your call your county freeholders, ask to see if they have such a representative. Get the New Jersey Resource Handbook for services like that for disabilities. In Passaic County, we have the One Stop Workforce Development Program, which helps people get some sort of job skill so that they can function. And there are ways that you can go through Social Security. There's a program where you can insulate the income you make through these jobs so that you're not excluded, or that you don't have more than the $2,000 that would exclude you from eligibility for benefits. With respect to adult adoptions, keep in mind that if you are going to engage in adult adoption, there has to be a 10-year age difference between you and the adoptee. So if I want to adopt my, let's say, little brother, and he's 3 years younger than me, that's not going to happen. It would have to be a 10-year age difference. And if you're going to disinherit your child, remember that a will is public record. So don't write on your will. It's public record in perpetuity. You can find wills in Passaic County Courthouse that belong to Garrett Hobart, of Garrett Mountain, things from 200 years ago. And keep in mind that these are public records. So don't write on your will something like, I'm not leaving my son any money because he was a drunk and he was allowed. people will see that, and for privacy's sake, you don't want to do that. You can just exclude them by saying, for reasons known to him or for reasons personal to me, I'm excluding or disinheriting so and so. And that's all I have at this point. But keep in mind that resource handbook is a good tool to start, to find a whole plethora of things that you can call or contact for services.
Thank you. Ms. Burnett?
I would like to take this last opportunity. Thank you for being a part of this. But anyone that needs to apply for benefits, I want everyone to know, especially not just because of COVID, but you are able to apply for everything online. Just about njhelps.org, and there's also njfamilycare.org. You can apply online, and we will address it as quickly as possible. And if you have any issues, you can also call our call center at 973-395-8000.
Thank you very much. I'm just putting the information online as well so people can receive it. Deana?
I just want to say thanks for having me, and call for help if you need it. If you're concerned about a loved one, if you're concerned about yourself, call for help. There are so many outlets out there, and the first place to go if you don't know who to call is call your local police, and they'll direct you to either the mobile screeners or to the hospitals that have screening centers for mental health. And thanks for having me.
Thank you. DeVero?
So if Crystal, if you can provide your contact information, if somebody want to get in contact with you, and we'll also post that in the comment section as well.
And I think I have also to Surrogate Toledo, I have your information as well. If anyone to get in contact with your office, they need to contact what number?
973-881-4760. I'll repeat it. It's the Passaic County Surrogates Court, 973-881-4760. At this point, we're working remotely. The doors are shuttered, but we're very much operating. You leave a message and we'll get back to you within a day or so.
Great. Thank you very much.
My number is 973-889-4263. Again, that's 973-889-4263.
Great.
And here at the Essex County Surrogates Court, if you want to call about adult guardianship, or if you have any matters that needs to be probated, administration, or have to do a superior court matter, that goes to us. Our telephone number is 973-621-4901.
Thank you very much.
Thank you. Stay well, everybody.
Thank you.
Everyone stay well. I appreciate it. So with that being said, thank you for participating in this conversation. Again, Mental Health Awareness Month. This is the final few days. And so mental health awareness is also you. Make sure you keep yourself mentally and physically, in perfect condition. If not, seek help. Don't let any stigma keep you from receiving the help that you're entitled to. And please use the services that are provided and use them as much as you possibly can. All right. Thank you, everyone. Have a great day. I hope to see you again.